This interview is part of the Oral History Project sponsored by the State Bar of New Mexico and its Senior Lawyers Division. I am Terrence Revo, a member of the Senior Lawyers Division of the State Bar. Today is August 30th, 2007, and I am interviewing Virginia Ferrara in Albuquerque, New Mexico. Before we get started, you had indicated that you wish to be addressed by Ginny. Is that correct?
That will be fine.
All right. Can you tell me, Ginny, was there anything about your early childhood or adolescent experiences that influenced your decision to practice law or become a lawyer?
When you say early, you mean like kindergarten, 6th grade?
Anywhere.
I don't know. I just always was kind of a pro-underdog kind of person, and I also was argumentative. I don't know if that came first or if it led me there or what. I used to argue with my mother about I'd always have to serve the dessert, and she would say I'd make a point of putting pie down with the crust toward the person as opposed to the point, and she told me, you always serve pie with the point toward the person, and I said, where, is that written down? So I think I was thinking about law even back then, even though I didn't know it.
When you were a teenager or in your early 20s, were there any television shows that you watched that featured lawyers and the legal business?
I am so old. I mean, we watched Westerns. I don't think they had any law TV shows back then.
Yeah, well, Perry Mason.
Perry Mason, that's right. How could I forget Perry?
Now, when you went to college, were there any of your educational experiences that impacted your decision to become a lawyer?
When I went to college, my goal in life was to get married. And I remember I had a lovely advisor. I say love. She was super. She was a maiden lady, as we say, and she called me into her office and she said, Miss Cushman, that was my name then, you have got to do something about your grades or you're never going to get into graduate school. And I thought, is she crazy? I mean, she obviously needed graduate school because who would marry her? But me, I'm going to get married. I don't need to do anything. So, no, it didn't cross my mind till much later to become a lawyer.
Well, tell us about what experiences you had that did inspire you to become a lawyer.
There are a couple. Before I was a lawyer, I was a school teacher. And that was in Albuquerque at Highland High School. And I tended to attract as students, because students could pick which courses they wanted to take to some extent. And I was kind of a rebel, and I got rebellious kids, and they were forever getting thrown out of their houses or knocked up or this or that or the other. And I think, this isn't right. Somebody has to stand up for these kids. So that was one of the reasons. Another reason was I was just kind of getting fascinated by the whole concept of the law. Another reason was that when you teach school, or at least back then, you had to be there at 7:15 in the morning. And I decided right away that I didn't want to be part of any enterprise that required my presence at 7:15 in the morning. So that, plus my then husband, was dead set against it. So put them all together. That's not a very good reason, is it?
Well, you had mentioned to me before that when you were in graduate school, some of your fellow graduate students were talking about law school.
Right, they were. I was just taking graduate courses kind of to kill time while I waited for my then husband to graduate from his graduate program, and so all these guys were taking the LSAT, and I thought I could do that, and we had to study international law, and I really liked that.
When you talk about the concept of the law and the way that you were looking at law affecting society, can you bring back any of those memories for us?
At what point in my life?
Well, when you were thinking about the kids in your class and how law impacted their lives and their connection with the legal system.
Well, it just kind of went back to my underdog mentality, thinking somebody's got to do something about this. I want to do something about this.
How do you take that underdog mentality and connect it with what you've done for the last 26 years, being the chief disciplinary counsel?
Well, because many of now not all, but many of the complainants are the underdog. We're not setting out to right wrongs for them. We can't do that. But sometimes we can find remedies for them or help them out, even though that's not the goal of the disciplinary system. The goal of the disciplinary system is to protect people in the future and not to provide anybody with a remedy. But some of these people are pretty sad, and sometimes we've gotten restitution for people, and if we work it out with the attorney.
Mm-hmm. All right, and I'd like to come back to that in just a little while. When you were in law school, were there any courses that you took or professors that you met that eventually influenced the direction that your career would take?
I think my favorite professor when I was in law school was a guy named Lee Teitelbaum, who taught domestic relations and juvenile law. In fact, he was a juvenile advocate, and it kind of tied into my wanting to help the kids I'd been the school teacher for. He was pretty good, pretty nice guy.
Well, he taught evidence at the law school that I went to.
Really?
Yeah,
you're kidding?
Yeah, at the University of Buffalo.
I didn't know that.
Yeah, he was there first, and then he came out to New Mexico. I didn't know him. I wasn't in his section at that time, but he was there before he came out here. And were there any courses in the law school that you took while you were in law school that you said, hey, this is really great stuff, I want to do more of this?
I guess evidence and criminal law, and I like slice of life kind of stuff. Taxes, real estate, and even wills and trusts. It just was like, in fact, and my least favorite course was business associations because it didn't have any drama. But, criminal law, juvenile law, that kind of stuff was kind of interesting, I thought.
So when you talk about slice of life type of things, what you really mean is life drama type of situation?
Judge Judy kind of stuff.
So when you were in law school, you graduated in 76, do I remember that correctly?
Correct.
All right. Who were some of your classmates that you were friendly with?
Well, my two best buddies were Lemuel Boyd, who's now an attorney in Santa Fe and has owned Capital Title Company, and Linda Bloom, who's a bankruptcy trustee, and Ken Waltz, who's the editor of the Journal, and Bill Tryon. In fact, we still get together for lunch about every 2 months.
Anybody else that you can remember in your class that you were friendly with?
Gosh, I wasn't unfriendly with anybody, as I recall. Woody Smith, Dave Archuleta.
Well, we all know, Woody, because he's been on the bench and is now, mediator par excellence.
That's right.
What was Woody like in law school?
He was Woody, same old guy. Actually, he didn't come to our law school until we were second year. He transferred in that year. And I think he was part of the Waltz Tryon basketball team that those guys played a lot of basketball back in those days. But they did a lot of other good stuff, too. They started a newspaper called The Tattler that was, the gossip rag sheet of the law school. We all looked forward to it with bated breath every month or 6 weeks whenever it came out.
When did you pass the bar?
In the fall of '76.
And how did you start your legal career?
Well, I wanted to be a public defender that worked with juveniles, but I didn't get hired. And I got interviewed by Jim Brandenburg, who was the DA then, and got hired to be children's court attorney and work with juveniles. And I thought, well, I guess I could, that would be okay, because it was kind of a problem-solving kind of deal. Children's court law is not quite as aggressive as adult felonies. You're more trying to see if this kid can be straightened out, Now some of them couldn't, of course, but a lot of them could.
So when you were back in juvenile court, were there any treatment options or alternative options available in the Albuquerque community for these kids that hopefully could be straightened out?
Well, a lot of them were labeled as chins, which was a child in need of supervision, and they'd usually get put on probation and have a probation officer. In fact, our branch of the DA's office was in the juvenile probation office back in those days in the basement of the courthouse. So we worked real closely with the probation officers. And there weren't that many programs. There was one called Ogaris, which I guess maybe is still in, I don't know if it's still in business or not. But no, there weren't that many at that time.
How long did you stay with the juvenile prosecutions?
I think it was only about a year. We had a case that came along of a juvenile who was accused of abusing her baby, and actually it was her stepson, accused of throwing him down the stairs, and she got bound over, as they say, to be tried as an adult, and I tried that case with Peter McDivitt from upstairs, and I guess he decided that I belonged upstairs in the adult division rather than with the juvenile division. But when I was a DA, an assistant DA, I did get the child abuse cases were always assigned to me.
So you wind up doing a lot of the child abuse prosecutions?
Yes.
Who were some of the attorneys you worked with in those early days in the DA's office?
Well, you were there, I guess.
I was.
Doug Henson and Sasha Seymour and Bob Schwartz and Marty Diamond and Kristen Anderson and Bob Martin and Dave Williams. Quite a crowd.
Those were some interesting days, weren't they?
They were.
I still see people like Ken Downs and Dan Schneider and Barbara, his wife.
Yeah.
And so you were there at the same time that all of those people were there also.
Yes, I was.
All right. Of the cases that you handled while you were a prosecutor, are any of those cases the type of cases that you would consider to be memorable cases, cases you thought were really important to do?
I think the most memorable case that I had as a DA was the case that we convicted the wrong guy, which was not a good thing. It was a murder case, a double homicide out in Torrance County, and the defendant's name was William Smith. I remember we had to try that case twice. The first time was a hung jury. Come to find out, his then attorney, whose name I will not mention, had apparently bribed one of the jurors. So it was an 11-1 hung jury. And the second time around, he was convicted. And I remember standing there arguing to the jury about this little window of opportunity that he had to have done it within this particular time, or he couldn't have done it, okay? And I'm like thinking, God, I don't know if he really did that or not. And then I had to talk to myself, and I said, look, it is not your job to decide whether he's guilty or innocent. You just put the stuff out there, and they decide. And I made myself feel better. Well, then, after he got convicted, he hired Alice Hector to do a habeas, and I ended up testifying for him that about... It's a whole long, big mess about some evidence that apparently his attorney was not aware of, that I didn't know the attorney wasn't aware of. And he got a new trial, and the victim's mother hated me, and it was a big mess. But he got out, and I'm glad. And he's still out, and he has a job now. He hasn't done anything to anybody since. And I don't think he ever did anything to anybody in retrospect.
That was also the period of time where the convictions against the motorcycle gang got turned around.
Right. Yeah, I was not involved in that at all.
Yeah, and well, by the time I got here, Ira Robinson was the DA.
Yes.
And I think Jim had lost the election primarily because of that.
Yeah.
When you were with the DA's office, aside from the case that you just talked about, any other memorable cases that you participated in, or memorable moments with some of your co-prosecutors?
Nothing really comes to mind. There were a lot of child abuse cases I remember prosecuting. They were kind of sad. In fact, when I left the DA's office and went to the public defender's office, it was with the caveat that I don't take child abuse cases, because if anybody came up to me and said, "Oh, well, the baby got a fractured skull because it fell off the couch," I, couldn't possibly be a good advocate for that person, because I'd heard that too many times.
When you left the DA's office, did you leave to go to the public defender's office?
Yes.
And why did you make that jump?
Oh, I guess I was still wanting to help the downtrodden, only it kind of took, it takes it's funny, it takes a little while to make that switch, because I'd be reading through these cases as a DA and I think, oh, that person thinks they're so smart, and I'm going to show him or her, and then you get over on the other side and then you realize, of course, after 2 or 3 weeks that they didn't think they were smart, they didn't think, period. But the transition is kind of interesting, but it's possible to do.
Memorable cases while you were in the public defender's office?
I have a memorable case, but I also have a memorable moment.
What's that?
The memorable moment. We were defending, and I can't remember this kid's name. He was like 19 or 20 years old, and he had been involved in a purse snatching of a little old lady, and the little old lady fell down, and she had, died, unfortunately. And he was looking at I can't remember what he was charged with, but it was like the possible sentence was 2 to 6 years. So one of the memorable things about that was every time we had a hearing, his mother would come to court, and every time she came to court, she would walk out in the hall and fall over in a dead faint. And every time she fell over in a dead faint, Justice Stowers would come out and step over her and it got to be like, oh, there she goes. Well, Justice Stowers kind of liked people to take pleas, and he would encourage you to take a plea. So he was encouraging us to take a plea, and I said, well, what did you... my client's kind of worried about the sentence that he might get, and what would you think? Well, I'm not going to say. He said, I'm not going to say if it's 2 years or 6 years. But, he said, I have never screwed one of your clients yet, and I'm not going to do it now. Well, there's a big letter. So my client pleads. Big letter writing campaign to the judge. All the people in the community are outraged. We go to sentencing, and 6 years, bam. And, of course, his mother faints out in the hall. And my client was a little upset and wanted to withdraw his plea. So I had to file a motion to withdraw a plea and allege that he was under the misimpression that perhaps he was going to get a different sentence than the one he got, yada-da-da-da. So we get there in front of the judge, and he says, well, Ms. Ferrara, what's the basis for your argument? And I said, well, Your Honor, my client was under the impression that he was not going to get 6 years, that perhaps he was only get 2 or 4. Well, where did he get that idea? Well, Your Honor, after talking to the court, I was under that impression myself. Well, what did I say to make you think that? I said, well, you implied that that's what you were going to do. No, I didn't ask you that. What did I say to make you think that? So I said, well, Your Honor, what you said was, I've never screwed your client before, and I'm not going to now. Well, the whole place went crazy, and he got red in the face and banged down his gavel. Things weren't quite the same between us after that. But And then I guess my memorable case was the William Wayne Gilbert case. After the Supreme Court reinstituted the death penalty, old Wayne came along, and he was the first one to be charged under the new death penalty statute. And there were 4 of us assigned to his case. Myself, Joseph Riggs, a gal named Debbie Bowl, and my former spouse, A.J. Ferrara. And the 4 of us worked on that case from February through August. And the week before we were supposed to go to trial, this was really strange. We all had different little jobs, and my little job was to keep the client happy. Because we had a seminar where somebody came from the Southern Poverty Law Center and said, you got to love your client, and you got to go see him every day. And I was the go see the client every day person. And I got, reasonably close to Mr. Gilbert, who was a very charming sociopath, as most sociopaths are charming. And the week before trial, it came to the attention of the district attorney that there was, after all, a plot afoot between Mr. Gilbert and an associate on the outside to have one of his attorneys kidnapped and held for ransom. And so Judge Traub took us off the case because we were like, oh my gosh. Now Wayne, after that, we stayed in touch until, well, bless his heart, he died about 4 years ago of cancer. Didn't get the death penalty after all, because Tony and I had pardoned him. But, and he swears that there was never any such plot. But it kind of gave us pause, and Judge Traub was worried that perhaps we wouldn't do a good job, thinking that maybe somebody was going to get kidnapped, murdered.
Well, that's one of the more bizarre stories I've heard.
It was a little bizarre. And I kind of lost my mind for a couple of weeks after that. It was like, oh my God, here we'd been so intense with this person, and then all of a sudden we weren't involved in the case anymore, and we weren't supposed to talk to him, and we couldn't talk to him because he had new lawyers by then.
Any other, we lawyers like to talk about judges, and of course the judges like to talk about the lawyers.
Oh, sure.
Any other favorite judge stories that you might have to share with us?
Well, I used to like Judge Baiamonte on arraignment day. He was always kind of funny. And sentencing. He loved sentencing. And he'd say to these people, come on up and get a little justice. And then he'd sentence them. Another time, I had a client that this was in front of Judge Traub, I had a client that was from Maine, where I grew up. And he and his cousin were charged with some nefarious plot. I forget what it was now. Anyway, they're both sitting up in the jury box in their blue jumpsuits, and I'm trying to argue to get my client out on bail, and Judge Traub says, well, is there anyone in the courtroom who knows this person? And his cousin in the box puts his hand up, and I'm like, not you.
So what made you decide to leave the public defender's office and go with the disciplinary board?
Well, I think after the Wayne Gilbert case, I was kind of stressed out, to put it bluntly, about the whole criminal law thing. That case stressed me out, plus, you remember those days where you'd start the week off and you might have, 6 cases on a trailing docket, and you wouldn't know which one was going to go, if the guy in front of you was going to plead, or if he was going to go to trial, or if you're going to be here, if you're going to be there. So you spend every weekend, getting ready for 5 or 6 trials because you don't know if your guy's going to plead. And it was kind of getting me down. So I thought this sounded kind of like something more tame.
Well, was it?
Yes, and to some extent. To some extent, yes.
When you accepted the position, what were your thoughts about what you were going to do?
Well, I wasn't really sure. I was going to be working for this nice board of people that were very pleasant, and I thought, well, this would be a nice change, working for these people. And I wasn't going to have, 6 trials a week. And apart from that, I didn't really know. It's not like I woke up one morning in the 7th grade and thought, by golly, I want to be a lawyer disciplinarian. Never in my head. It was just it's like most things that people do in life. I think they just kind of drift into it,
So as you were drifting into this job,
yeah.
how was it set up? I know that Mr. Gilbert was the chief disciplinary counsel at that point in time.
Right.
And he was in Santa Fe, as you had mentioned
Correct.
to me when we were talking before. So how did you wind up doing whatever it was that you were supposed to do?
Well, what would happen back in those days, the early days we were the branch office in Albuquerque, and it was just me and a secretary. Mr. Gilbert would come down to the office on Fridays. All the complaints would have been written to him, and he would bring down the ones he thought that we should handle. And about 5 or 6 or 7 a week, maybe. We weren't a booming business back in those days. and we'd, or I would, write a letter to the lawyer and listen to his response, and just a lot of them would get dismissed. The first big case I had involved an attorney. I learned right off the bat that sometimes the ones that sound the worst, the complaints that sound the worst, nothing, An example, my lawyer is a vampire and drinks blood on weekends with other people out on the mesa. I mean, that's not usually good. But then one that you can look at and say, oh, this one is going to go away real fast. Somebody wrote and said, I put some money into the court treasury in connection with my probate, and they won't give it back. And I'm thinking, oh, good, I can send this off to somebody else. So I call up the court, and they said, we don't have any money for this person. And what the lawyer had done was dummy up a receipt from the court and put a stamp from something else on it and Xerox it through and give it to the client, and had taken the $15,000 himself. So I learned that things are not always what they appear to be on the surface.
Wow. Were the types of complaints against lawyers back in, we're looking at 1982,
Mm-hmm.
were the types of complaints against lawyers much different then than they are today?
In a sense, we did not have our brochure that back then that we send out and tell people, well, we can't get you any money back, and we can't change the outcome of your case, and we can't provide you with a personal remedy, and so people would kind of file complaints looking at us as the last resort. They would want their conviction overturned, or they would want their divorce settlement reopened, or I remember a complaint that said my lawyer didn't do the right thing in my divorce because I specifically asked for my graduation tassel and the Snoopy bedspread, and I got neither one. And, we can't really fix that. And now that we have our brochure to send out, and people understand that they're not going to get a personal remedy, then the kinds of complaints are a little bit different now, a little bit more sophisticated, I would say. Lawyers are complaining more about other lawyers than they did before. Judges are filing complaints more frequently than they did before, and we're not as involved in as many divorce disputes. However, I say that with a caveat. I should tell you that this morning we have a person who filed a complaint. This is a non-lawyer, and his complaint was that these lawyers took over his client and won't let him participate anymore in the litigation. Well, he's not supposed to be practicing law, so there's not. We're not going to do anything to them. We wrote him and explained this. Now he wants it reopened. So we send it to somebody else, a board member, which is what we do when somebody wants the thing reviewed. And the board member said, no more investigation. This is fine. He calls up this morning and says, well, the Chief Justice told me that I can meet with the entire board, or no, the Chief Justice's secretary told me that I can meet with the entire board. And I said, well, you have her call me, and we'll take it from there. Well, no. Don't you believe me? I do have her call me. Well, he didn't, and I called, and this lady answers up at Justice Chavez's office, and I said, I need to speak to Justice Chavez's secretary, and the lady says, well, he didn't really have one today. Can I help you? I'm his paralegal. And I said, well, this person called about, him. Yes, he did call up here, and I've tried everything in the world to make him go away, and, I can't find him in the bench and bar. I said, well, he's not a lawyer. Oh, okay. And, but so we do still get a few fringe people that hang on. Am I wandering too much?
No. Most people, one of the reasons that I asked you to come here today was because most lawyers, and there are 6,000 or so lawyers in the state, don't really know about what the legal community looks like from your perspective. They just know that there's this disciplinary thing, and most of us don't have a tremendous amount of contact with the disciplinary committee. So, that's part of what we're trying to do here today, is that if people want to watch the video at some point.
Yeah, they'll look at this and they'll say, I was worried about her.
But it's very important for people to be worried about you, don't you think?
Well, it's important that they write back to me when I write to them. The reason I say that is because we have a lot of people who have, I won't say a lot, but more than I would expect, that get charges filed against them simply because they ignore letters from the Office of Disciplinary Counsel. And one of the rules that we work under is we can dismiss complaints without formal proceedings, but in case of doubt, all doubts shall be resolved by way of formal hearing. Well, if we don't hear back from somebody after writing to them 2 or 3 times, then we have doubts. Okay? So we have to file formal charges. But did I answer the question right or wrong?
No, well, you didn't quite answer the question that I asked.
Well, you can yell at me and say, that's not what I asked.
That's not my job. Where that question was coming from is that, you've got 6,000 lawyers sitting in their offices, conducting their legal business on a day-to-day basis. And hopefully, most of the people, a vast majority of the people, practice with honesty and practice with integrity.
I would say that's true.
We do have a blind business in that people don't really know much of what we do. Even our clients who are well educated and who we talk to don't really understand much of what it is that we do on their behalf.
That's true.
All right. So a lawyer has a tremendous fiduciary responsibility, as you are well aware. Mm-hmm. Within that fiduciary responsibility, there are several ways that you often can choose to go. And if a lawyer knows that there's a strong disciplinary counsel and a strong disciplinary committee out there, then that thought is really sitting on his shoulder as he's evaluating options. At least that's my perspective. Mm-hmm. Is that something that you have seen, or do you believe that to be accurate?
I guess that's true. I would say that the vast majority of attorneys in New Mexico are doing the best job they can and are doing a good job and are honest and are responsive to inquiries from our office and are just doing things right. You're correct that I think some complaints come about because of a misunderstanding of a lawyer's role, but I don't know if people are afraid of our office, but I think there are enough cases out there that lawyers can look at and see, like, gee, I don't want to do that. In fact, when I first became disciplinary counsel, the court did not write opinions. And there would just be a little note that so-and-so got suspended, so-and-so got disbarred. And fortunately, over the past 25 years, the court has begun issuing opinions to guide lawyers more in their conduct. But you hear all these horrible stories about lawyers, and I always, when I have to give these little speeches sometimes, I say, well, we get about probably 850 complaints a year. If you figure that there's 5,000 or 6,000 lawyers out there and that each one of them has got to have at least 10 clients, and so that's 50 or 60,000 possible complaints, multiply that by opposing counsel, and you can double that, and we only get 875 complaints, I'd say that the lawyers are doing pretty well.
Yeah, that's very interesting, and that's part of what we were looking for, is to get that perspective. Because, it's fairly common in today's world that lawyers get bashed.
Oh, yeah.
All right, and there's no dearth of television programs or movies that shows lawyers and demonstrates lawyers in a bad result, in a bad way. So that's very interesting to hear the way you look at it in terms of the number of potential complaints that could be out there as opposed to the ones that you actually get. There's been some comment recently that the number of disciplinary complaints are dropping. Is that accurate?
Yes, the volume, the sheer number, is probably dropping. The ones that we get are probably more serious. It's a higher percentage of serious ones, as opposed, so our business hasn't really fallen off. The volume has, but the number of complaints that require action has not. That may have gone up. I don't know if that makes any sense.
Yeah, it does. It does. Basically, you're saying is that the smaller stuff, the lawyers are getting a better handle on, or people are not complaining about.
Well, and I think part of that is the State Bar has instituted the CAP program. It's run by Tanya Herring, and it's the Client Attorney Assistance Program. And whereas before people would call it and say, my lawyer doesn't return my phone calls, they now can call up Tanya, because the only thing we could do was send a complaint form. And so we'd have all these forms about my lawyer doesn't return my phone calls, which, by the way, nationally is probably the biggest gripe that people have about their lawyers. And some people expect too many phone calls back, but that's neither here nor there. But now they can call Tanya and say, my lawyer doesn't return my phone calls, and she can say, what's your lawyer's name? And they'll tell her, and then she will call up the lawyer and say, hi, this is Tanya Herring, and the client, and your client so-and-so is feeling neglected, and I would suggest that you might want to call him or her, and otherwise he or she will probably file a complaint with the disciplinary board. And even though most lawyers realize that an isolated, unreturned phone call is not going to subject them to discipline, they'd also prefer not to take the time and trouble to write to me, if they can avoid it. So I think that's part of the reason for the falling off of complaints.
You had said that the most numerous complaint about lawyers nationwide is failure to return phone calls. Mm-hmm. Given your experience, what's the dynamic at play there?
I think it's a failure of some lawyers to communicate to clients that, look, I'm here for you, but there are going to be days that go by where nothing's happening. There's going to be weeks that go by where nothing's happening. And every time you talk to me or I talk to you, it's going to cost you money. So I'm only going to talk to you on very important, and when I have something to tell you. And I think another reason is some clients are just so, people don't go to lawyers to rent a friend. They go to lawyers because they're over a barrel, and so naturally they're shook. And they need a lot of hand-holding a lot of times, and maybe more hand-holding than the lawyer's ready to give them. And so I think it's maybe unrealistic expectations on both sides. I think if lawyers would take more time to explain to clients that, this is the way it's going to be, and this is how long it's going to take, and yada da 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 da, then it would help. I remember reading an article one time. This guy was writing about desk-side manner, and pointing out that it's kind of like bedside manner for doctors, desk-side manner, and that he had witnessed this lawyer talking to his client in court, a divorce client, saying, "Oh, this is just nothing." And well, she'd never been through this before, and he was reminded about when he was on an airplane, and we've all been on airplanes, and you listen to the stewardess go, "And in case of an emergency, the thing's going to come out, and the lights are going to go on up and down the aisle, and this is going to drop out of here, and be sure to fasten your," and everybody tunes it out. If you've been on a plane, you've been there, done that. But if you've never been on a plane, he said he was sitting next to this little old lady who was like practically taking notes at what the stewardess was saying, and that we have to remember that sometimes our clients are like the little old lady who's never been on the airplane and needs a lot of instruction and reassurance.
Do you think that a problem like that could be remediated in the initial client letter from the lawyer?
I think it would be better, well, it certainly could be included in a letter, but I think a face-to-face chat for some people would be more meaningful. If you're looking right into somebody's eye and they're telling you this, it's better than reading it on a piece of paper.
In your years at the disciplinary board, what cases stand out in your mind? And I understand that maybe you might not want to disclose names, but that maybe some types of cases that you worked on that you thought were a particularly good outcome, either for the disciplinary board or the complainant or the lawyer.
Well, of course, my case that lived with me for 7 years, I think it was, is probably my outstanding, in my mind, case, involving a New Mexico lawyer who was a United States attorney in Washington, D.C., and who took to heart the advice of then Attorney General Thornburg, or former Attorney General Thornburg, that after all, some of these disciplinary rules don't apply to you folks, and your job is to go out and get these people. And the one that was in question was the rule, our Rule 16404, or Model Rule 4.4, that says you can't, 4.2, sorry, that if you're on one side of a case, you cannot talk to a represented party on the other side of the case without that lawyer's permission. So this guy's sitting in his office, and some guy in jail. I mean, they're always like, in fact, as a DA, I used to have people call me from jail that think I'm going to talk to the DA straight up. And I'd say, I can't talk to you, talk to your lawyer. But this guy thought, well, I'll talk to this guy. He called me, what the heck. And so they had repeated conversations about the guy's case. And the judge, there was a motion to suppress filed, and the judge in D.C. said, this is wrong, and I'm turning you over. I'm not going to suppress the statements, but I am going to turn you over to the Disciplinary Board of District of Columbia. So they investigated, and the position of this lawyer was, I don't have a D.C. license, and you don't have any control over me. And so the D.C. bar said, fine, send it to New Mexico. Send it to me, and their position then was, frankly, my dear, we don't give a damn what you think out in the provinces. And so we filed charges, and bingo, we're in federal court on a motion to remove because this is a federal matter, and the Supremacy Clause says that we don't have to go by your little provincial rules. And we got over that hurdle, and Judge Borsiaga wrote a very compelling opinion that said baloney, basically. So I'll forgo with our charges again, and then wham, I get served with a lawsuit out of the District of Columbia trying to enjoin me from interfering with law enforcement activities back in the District of Columbia. And that went on for 3 or 4 years. And finally, the D.C. Circuit Court threw it out because there was no jurisdiction over me. The long arm didn't reach that long. And then we finally got back to the case at hand after 5 or 6 years, and the court formally reprimanded this person. And I think, and that was kind of interesting. I mean, going back to D.C., I had a lawyer that, this was funny too, and I got to tell you this. I'm not a state employee, but we're covered by risk management. And the AG was initially, they weren't asking for money, so the AG was appointed to represent me, and I wasn't real comfortable with that because I thought, well, these are prosecutors. So I called up my buddy in the D.C. office who had sent me this wonderful case, and I said, look, man, you got me into this mess. Now get me out. He called back and he said, I got 4 law firms that are dying to represent you pro bono. This law firm is they're like E.F. Hutton. When they open their mouths, people listen. And this law firm here, they're so nice. You would love them. They are so nice. And then there was a third law firm, and then the fourth one, he said, and these guys are animals. I said, I want the animals. And I'm always telling lawyers, be polite, da-da. But when it's your neck is in the noose, I want the animal. And they would send me bills, or send our office bills every month and then write them off. And I think the total bill came to something like $240,000, which they wrote off. We didn't have to pay for it, but it was a learning experience.
So the eventual outcome was that you did have jurisdiction and that there was a formal reprimand?
Yeah. And this guy, by the way, this is apropos of nothing, but has gone, he was like, I'm just, you're making me the poster boy for this, and it wasn't my fault, and And I'm advised that he, eventually got his license in D.C., and has recently been the subject of further proceedings wherein he bribed several witnesses as a prosecutor, and there's a recommendation of suspension for him. So I think he was a bad guy.
Well, maybe he looked at things in a bad way.
I think his attitude is everything, isn't it?
Do you see much attitude in terms of the way you have to conduct your business?
Yeah, I do see attitude, and to some, a lot of times attorneys are, and I can understand this too, but they're kind of outraged that anybody would see fit to criticize them, especially if it's another lawyer. Or they will, we have this little thing that we can issue called a letter of caution, which isn't discipline at all. It's just the attorney came real close to violating a rule, but didn't quite. And so we call it a dismissal, but we issue them a letter of caution that says, please bear in mind that in the future, you might want to think about this, and this, rather than what you did this time. Otherwise, you could, violate the rule. And people will write back, and attorneys will, and be outraged. Like, how dare you criticize me? I want this reopened. I want it reviewed. And I'm like, we're not reopening a dismissed case. We dismissed it. We're just giving you advice. So you can take it or leave it, whatever you want. So, yeah, there's a little attitude out there.
Any other significant cases that stick out in your mind? You've handled, or you've reviewed thousands of them in your 26 years.
Well, there have been some complicated trust account cases, and interestingly enough, there have been cases where attorneys have literally stolen money out of their trust accounts. There have been other cases where attorneys literally don't have a clue on how to keep records about a trust account, which leads to problems. That they're not dishonest, but they're at a loss what to do. And I have talked myself blue in the face to try to get the law school to teach accounting, a little bit of accounting to everybody. Everybody at the law school is going to go work for the Rhodey firm, right? They don't need to take law office management, because I'm always told they can take law office management. But, what money goes into trust, what stays there, when it comes out, how it comes out, is just totally foreign to a lot of people. And so one time I had a guy who was merrily bouncing checks of his trust account, and I said, look, come and bring all your trust account records for the last year, your bank statements, okay? And he did. And they were still in their envelopes. So he had no idea that these checks were bouncing around the way they were, because he didn't look. And, little things like that. I wish would be taught to attorneys.
What kinds of cases are you seeing today, for example, that you wouldn't have seen 10, 15 years ago?
Well, I'm trying to think. I can't. That's really hard to say. I mean, and I shouldn't say that because there isn't a week goes by that I don't look at someone and say, they can't make this stuff up. You read these cases in law school and you think, who made that up? And you think, nobody. but there's always a new twist. But it's coming out of the same old. Maybe we're not communicating. One of the great things that have, if you had asked me what kind of cases are you not seeing, as opposed to what are you seeing, I could tell you and be very happy that we are not seeing attorney advertising cases because people have gotten used to the idea that attorneys can advertise, and the Legal Advertising Committee has gone bye-bye and is not referring cases to us all the time, and everybody's happy about it. I think that the consumers are happy. I think the lawyers are happy. But the only time we get anything about advertising now is there's this multi-jurisdictional practice thing kind of heating up, and lawyers maybe from Texas are advertising over here, and that is troublesome to a number of people. But all the phone book ads and the letters, and all about the letters.
Yeah, I do. Why did the advertising committee get disbanded?
I think it was for a number of reasons. One was they couldn't find people that wanted to serve on it, and I can see why, because those poor people would meet once a week and go through attorney advertisements and phone books, and this is not what you'd call an exciting thing to do, and so finding warm bodies to do that was becoming difficult. When the committee first began, I remember Linda McDonald was executive of the bar, and she was so thrilled because the $50 per ad that you were supposed to send in to get it reviewed, the state bar was going to get, and wasn't that great, and we're going to get all this money, and yada yada. Well, the advertising committee went in the hole, and then our office had to bail them out to the tune of about $18,000 one year. So there was that. There were probably 5 lawsuits filed against our office during the period of time that the Legal Advertising Committee was in business, and they were all about advertising. They were not, nobody else sued us about anything, but people sued us about their ads and the Legal Advertising Committee and the First Amendment and yada yada. And we lost several of those, and the court had to pay that. And I think the court finally decided, we had this committee in place to guide people through the initial stages of appropriate advertising, and this wasn't meant to be something that would be going on forever and ever and ever, and they have served their purpose, so we're going to shut down that committee now, and you're on your own, folks.
In terms of them serving their purpose, do you believe that anything good came out of the advertising committee process?
No, personally. Well, no, I shouldn't say anything good. Before we had the Legal Advertising Committee, people were sending me their ads and saying, "What about this? Is this okay? Is this okay?" And since we can't give advisory opinions, it was kind of hard, put us in a difficult position. So I guess we, didn't get any more of those letters from people. But it was. I think it was an experiment that probably, they'd say the road to hell is paved with good intentions, and I think this was made with the best of intentions, but didn't work out real good.
With the advertising committee gone, with your office not being authorized to give opinions, what is the current standard regarding advertising?
The current standard is you may not have an advertisement that is false or misleading. That's it.
So basically, it's a commercial free speech issue. Tell the truth and you're okay.
Mm-hmm. Or don't mislead people. And as a practical matter, I don't know as we would probably do anything about an ad unless we had some warm body, some person that said, I saw this ad and it said yada da 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 and I believed it and this is what happened and I didn't. I mean, we did have, I remember, we did have an ad that came up, this is maybe 8 or 10 years ago, that didn't go through the legal advertising committee, but we found it to be false and misleading. And it was just an attorney's ad, this little tiny thing in the newspaper that said, uncontested divorce is $100. And that's all it said. And well, come to find out, this attorney never saw an uncontested divorce. And so everybody that would go there expecting to pay $100, and I think the public believes that an uncontested divorce means we both want out. And they don't realize that it means, well, who gets the house, who gets the kids, who gets the dog, who gets the tassel, all that good stuff. So we had him change his ad. But other than that, we never got any complaints from the public, hardly at all, about advertising.
Yeah, so what you're really talking about with that small ad is a typical bait and switch.
Yeah, which is misleading.
Right, inherently misleading.
Yeah.
When the advertising issue started to boil back in, let's say, the late 80s, how did you look at that issue? How did you look at the attorneys that were doing full-page ads in the Yellow Pages, the attorneys that were doing direct mail solicitation? There was also some attorneys that were doing telephone solicitations. How did you look at that whole issue of that new kind of advertising?
Well, I personally was not offended. And I think part of the reason for that was that by some fluke of fate, I ended up on an ABA commission called the Commission on Attorney Advertising. And I was on that commission for 3 years. And we did all kinds of studies and interviewed all kinds of people and looked at ads, this, that, and the other. And the committee's report, when it came out, our committee's report, came to the conclusion that attorney advertising is probably going to be helpful to most people, because most people don't have any idea where to go when they have a legal problem. And as long as the attorney advertisement is straightforward and not misleading, even if it's tacky, because there's some tacky people that like lawyers, that need lawyers too. So that was kind of my feeling about the whole thing. The only times I say I never got a complaint from a person, we did get complaints from time to time from people who got letters from people that were soliciting business for people involved in accidents, and I guess attorneys would go look at who'd been arrested for this, that, and the other. And usually they were from parents whose kids had, gone on a joyride and gotten in trouble and, run over the neighbor's rose bush or gotten into some kind of a mess, and then they'd get 3 or 4 letters from attorneys saying, we can help you, and the complaint would be, how do we teach this kid that there's consequences to their actions if these attorneys keep writing? But that was about, the extent of that.
Anything else regarding the advertising that, from the last 20 years or so that you'd like to share with us?
Not really. It's not one of our main issues. It's not one of my main issues. I think our last advertising case has gone to rest, finally. Now, the ensuing litigation has not, but the case itself has.
There has been a thought amongst, that was commonly accepted, that amongst some of the more senior members of the bar, that lawyers that advertised were not good lawyers.
And I think that some of the senior members of the bar still think that. I mean, I can't read their minds, but if they're old school, and I hate to say it, I guess I must be old enough to be old school myself. We were all taught, we had to take ethics. That was the only course in law school when I went there that was required. Otherwise, you take what you wanted. And I've always been of the opinion that required courses were required because otherwise nobody would take them. And so, and they took attendance at that one too. So we go in there and at least a half the semester, or maybe not half, but a good month was taken up with how tacky it is to advertise and how we are a profession and we don't need to do that sort of thing. And so I think that people schooled in that train of thought probably still hold the belief.
Has your office been involved in the programs that have been set up to help lawyers with disabilities like drug and alcohol or emotional problems?
Well, one of our staff attorneys is on that particular committee. I can't think of the name of the committee. Bill Stratford's committee.
Right. I forget the name of the committee too, but it's designed to help lawyers with emotional or drug or alcohol kinds of problems.
And help the committee help to draft the rule that says that anything said to a lawyer in the course of someone consult, like if I come to you and say, "My God, I'm drunk all the time. What am I going to do?" You can send me to them, but you don't have to report me to the disciplinary board. There's a confidentiality thing there to make that more possible. And we've worked in some cases where there's been an attorney with either an alcohol or drug or depression problem. Actually, my hero these days is Briggs Cheney, because cases are so wonderful when he's on the other side, and if there's a problem of that nature, he generally is. And his idea is like, work with me, and so we try to come out with a solution that's going to help the lawyer and prevent future problems.
Okay, let's go off the record now. We'll change the tape.
You mean there's more? Okay.
All right, we're back on the record with the second part of the interview with Ginny Ferrara. Today's date is August 30th, 2007. Ginny, one of the things that I wanted to ask you about is what type of actions, what type of things that lawyers do warrant the different levels of discipline that the disciplinary board can recommend, from disbarment being the most serious down to letters of caution.
Well, okay. Letters of caution are not a form of discipline. They're a form of dismissal. So, forget that. And each case is decided on its own facts. But as a general rule, if we're talking about defalcation of trust account monies, if we're talking about conviction of a crime, then the sanction is going to be disbarment. If we're talking about someone who perhaps has neglected not one but a lot of cases, we call that affectionately, those are our frequent flyers, or someone has drifted away from the dock, it'll be, sometimes a lawyer will never have heard of that person, and then here come all these complaints like the lawyer's not calling me back, the lawyer missed my hearing, the lawyer did this, the lawyer did that, and the lawyer's not answering to us, and we have to file charges, and it looks like things are pretty much out of control in the practice. Then that would be a suspension, or it could be a suspension with probation depending on the cause of the problem. Or it could be, probation could include drug and alcohol treatment and counseling. or it could include a law office management kind of thing that some people just can't seem to get everything put together right. But that's what would generally be suspension. Reprimands, I'm trying to think of the reprimands that have been given lately would be rudeness, well, I'm not saying just any old rudeness, threatening another lawyer maybe, or a conflict of interest that gave rise to a real problem. It's really hard to say because categorically it's not like, okay, you do this and this is what's going to happen. The court and the board sort of look at things on each case as a case-by-case basis.
Would it be fair to say that you're really looking to fashion a remedy that's appropriate for the circumstances as well as the nature of the problem with the lawyer?
Right. I mean, let's face it, some people are beyond help, okay? And I'm thinking of a disbarment here where the lawyer the first time around had trust account problems and was suspended and was supposed to, keep very careful trust account records. And boy, he was clever because he got himself his trust account and the records were great. And then he had this other account that didn't have any records. And so the next time he came through the system, he got disbarred. And there are, unfortunately, a few people like that. But generally speaking, what we're wanting to do is take the lawyer and maybe turn him around a little bit so that this doesn't happen to people in the future. And most lawyers are, appreciative of that. When necessary, even though we're not providing remedies to complainants, there can sometimes be a restitution ordered by the court or the board, or we do plea bargain even, or actually it's not called plea bargaining, it's called consent to discipline, where a lawyer will consent to a certain sanction and agree to make restitution or agree to do this, that, or the other to help the client out or redraw the will or whatever.
Do you often find that lawyers are appreciative of the process that you put them through?
Well, not always, but occasionally somebody is. Okay. Oh, gosh, wow. I had this lady lawyer one time and said, boy, I wish I'd been on probation years ago. I just loved it. It was so much better. Things were so much better after I got on probation. I'm like, good. That's good. But, it's more rare that occurs. Although lawyers, by and large, I think, feel that, and they've said, or their lawyers have said, that they were treated fairly, even if they didn't like the outcome. Sometimes, like, well, I really kind of deserve that. I'll try to do better in the future.
You had mentioned that a lawyer being convicted of a crime could face disbarment. By a crime, do you mean a felony or any crime?
I mean a felony or a crime involving dishonesty.
All right, so
the court has said that lawyers on probation for a criminal offense should not be practicing law as a matter of just policy. They have, to my knowledge, on 2 occasions made an exception, and that would be when the lawyer was given a conditional discharge as a sentence, and probation. Do you know about that sentence? We didn't have that when you and I were in the DA's office, but what it is the lawyer enters or the person enters a plea of guilty or nolo, and the court will say, all right, I'm going to impose a conditional discharge, which means if you'll serve on probation for a year, then this will all go away, and it won't be counted. It can be counted in habitual proceedings, but not for any other reason. It is not counted as a conviction. And
like
in
the pre-prosecution program we used to have?
Well, no, it's different than that. It's not pre-prosecution. It's something the court can impose as a sentence. And we recently had a case where I felt so sorry for that attorney. He bopped his girlfriend in the nose, I guess, and she'd been beating up on him for years. And he finally had it, went, and he said, "Yeah, I did it." But he got a conditional discharge, and it was like, man, she almost deserved it. I hate to say that. I mean, people of my gender will probably be kicking down the door. But in this particular case, we all felt so sorry for this guy because he was a good kid and he'd never done anything bad in his life apart from this one time. And I don't even know why his lawyer let him plead guilty. I mean, I think he had a self-defense defense. But anyway, he got a conditional discharge, and so he didn't get disbarred. He only got put on probation.
All right, so if somebody had, let's say, an aggravated DWI, where there was an accident with some injuries, that could be a felony charge. And if he pled or got convicted of that and wasn't given a conditional discharge,
correct,
that lawyer could lose his or would lose his license under what you stated.
Probably so. Thank God we haven't had one of those.
Would that be a disbarment, or would it be a suspension with conditions like you described before?
That would be up to the court. It would be. It's odd. There's so little difference, and I think this shocks people, between disbarment and suspension. And as a practical matter, the only real difference, there's two real differences. One, the name, the stigma of the word disbarment, of course. The other difference between that and suspension is, in disbarment, you have to petition the court for permission to apply for readmission. With suspension, you just apply for readmission. And I think people, the lay public, believes that when someone gets disbarred, that's it forever. And I think there's only 2 states in the nation that have permanent disbarment. And ours is, it used to be 3 years and now it's 5. And a suspension can be, I've had people that got 5-year suspensions, so it's not a whole lot of difference.
So when you're suspended during that suspension period, be it 30 days or 5 years, you can't practice law.
Correct.
However, once that suspension period is over, there are certain other requirements that would be placed upon you as you come back into the practice.
Correct. You have to go through a reinstatement hearing and show that you're once again fit to practice law, and the court can choose to reinstate you on a probationary basis, or just reinstate you.
When those type of things happen, does the court typically reinstate on a probationary basis?
Usually.
In terms of complaints, do you see? You had mentioned that you were getting more complaints from judges. Is this something that is a relatively new phenomenon?
The board is working through this right now. We've had a crisis of confidence. We didn't used to ever hear from judges. Technically, if a judge is in a case where an attorney is convicted of a crime, under our rules, they're supposed to report to us, but they frequently have not done so in the past, and I think that's not because they're trying to thumb their nose at the board. It's just that they've got other things to think about and don't remember, pretty much. We used to get complaints just from from judges who were distressed at attorneys being rude in their court, things that could have been handled by a contempt citation that they would send over to us instead. And the board and the judges have been meeting a lot lately to kind of define whose jurisdiction, I mean, where your job starts and where mine ends, kind of thing.
So what type of actions do you think that a judge would see or could see that would require them to report the attorney to the D board?
You mean apart from a criminal conviction?
Yes.
I would say that filing of a false pleading that the judge knew was a false pleading, or it came to light, perjury, of course, being excessively rude or berating a witness unnecessarily, that kind of stuff. Contacting the judge ex parte, maybe?
In New Mexico?
Well, yeah.
And would it be fair to assume that if a judge sees that there might be some misappropriation or mishandling of money during a civil or a criminal proceeding, that the judge would be obligated to report the attorney to the D Board?
We would hope so, yes.
Now, there is a requirement that, as an attorney, that if you see a violation of the professional conduct rules, you're obligated to report that, is there not?
There is a rule to that effect. And I wish I had my rules with me so I could read it chapter and verse, because it doesn't say anytime you think something smells like there's something rotten in Denmark, you have to write to the D Board. It's when you have information that an attorney has done something that reflects adversely on his or her fitness and yada da 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 da. And sometimes it pains me to say this, but I think some attorneys, will glom onto that rule just because they're pissed off at opposing counsel, and that's not what it means. It means you really have to know something. You just don't have to. I'll get pious letters sometimes, like, it's my responsibility to inform you that, and it pains me greatly. And you're like, oh, come on. But yes, there is a reporting requirement, and there have been cases, not in New Mexico, but in other jurisdictions, where attorneys have been actually disciplined for not reporting misconduct of fellow attorneys. Notably in Illinois, I know there's a case there where that happened. We've never had occasion to do that.
With such a large percentage of women going to law school these days and becoming lawyers, are there a number of complaints from the women attorneys as to how they have been treated by the male attorneys in the profession?
I've only gotten one, actually. And this woman attorney was upset because the male attorney complimented her on her attire. And I'm thinking, like, what's wrong with that? It was, no, we don't get very many. And I, for one, am opposed to a suggestion. There's a Rules of Professional Conduct Committee that's suggested to the court a number of revisions to our rules. And they have suggested that our court adopt the rule, I think it's rules, it's 3.0 nationally. It's that forbids attorneys from having sex with clients unless they had an ongoing relationship prior to the attorney-client relationship. And I'm thinking, oh my God. I mean, do not take us there. Please do not take us there. I mean, can you imagine the mess that would be? Can you imagine? Okay. For example, I think the notion behind such a rule would be to protect vulnerable women from the advances of men when the vulnerable woman is in an emotionally fragile state. Okay. We can deal with that under the present rules. We can deal with it under conflict rules. But how about where you have a high-powered lawyer in a silk stocking firm that works 80 hours a week and only deals with corporate clients and never sees a client never has any social life unless it's with the client. Maybe they fall in love. Or how about the other party says, I think that my soon-to-be ex-spouse and her lawyer are getting it on. And then what do? I mean, they have to come in and confess? It would be a mess. Just don't want to go there. Don't want to go there. You got more than you asked for there, didn't you?
That kind of is a good segue into this question, is how do you balance the rights of the attorneys that are being complained about with whatever rights the complaining clients may have?
Well, the rights of the complaining clients are to have their complaint investigated, and that's really what their right is. And they also have a right to have if it's dismissed, to have a review, and they have a right to believe, or to, they have a right to a process. There's a process. They have a right to have us follow it, and attorneys have the same right to have us follow the rules governing discipline, and not be judgmental. Give them a chance to explain themselves. If we don't understand what the explanation is, we can ask for more explanation. They have a right, so hopefully that we don't rush to judgment. They have a right to a hearing. They have a right to appeal.
In your years of practice, how have you seen the practice or the legal community in New Mexico change during the course of your career?
I think it's a little more formal than it used to be. Back when I first started practicing law, it just seems that it was more collegial back then, that it's more dog-eat-dog now in some ways. And I blame that on the public for not getting in enough accidents, because there's not enough work to go around. No, I'm being silly. But there is a lot of tension in the bar that I don't think used to be there. And perhaps it is that the competition is more fierce. That's the only reason I can think of.
One of the things that Justice Franchini said during his interview was that he sees that type of change coming from the increase in the number of lawyers, and that lawyers, for the most part, don't really know one another the way lawyers did back when the community was smaller.
I could agree with that.
And what Gene said was that back then, if a lawyer was stepping out of line, either with their clients or with their with the other lawyers in the community, somebody, usually one of the senior lawyers, would sit down and talk to them.
Well, and as a matter of fact, I think the disciplinary board only started to be in existence in 1973, and before that happened, problems with lawyers were handled by the local bars. And I mean, I don't believe they very often could get another lawyer disbarred, but they could certainly take a lawyer under their wings, and I think that's the way things were handled by and large.
Any other changes that you see in your 26 years with the D Board?
Well, I think that's the most notable one.
What do you think the D Board's most significant contribution has been to the legal community?
I think they've made quite a few contributions that over the years. We've had, one of the responsibilities of the D Board is to make suggestions for amendments to the rules. Sometimes this is kind of a Band-Aid approach. After a problem pops up, we think, oh man, we should have a rule that deals with that. But we were talking, for instance, about letters of caution. And it used to be that the least that could happen was an informal admonition. And my predecessor, chief counsel, would sometimes offer people an informal admonition when he didn't have enough evidence really to proceed with charges if the person said, take your informal admonition and fly a kite with it. And so he sort of invented this letter of caution. And the board said, no, we're not going to do that. You have to follow these rules, but if you think that this person could use a little guidance, then we'll suggest to the court, and the court agreed that we have these letters of caution. The board has also suggested revisions, for example, to the rules governing how to maintain your trust account records, because all the rules said originally was, don't mix your money up. And now there's one of the rules governing discipline that outlines step by step what records would be considered adequate in case somebody's wanting guidance along those lines. And I think the board has made quite a few suggestions that have probably been helpful to the practicing attorneys. The board now has 2 members that are non-lawyers, and that's given them a lot of the lawyer members' insights into how the public is looking at stuff, and I think that's been good.
Okay. Any other aspects of your life or your career you'd like to share with us?
No. I think we've talked quite enough. I just wanted to get through this interview without sounding like Miss Teenage South Carolina, you know?
But from my perspective, you have not sounded like Miss Teenage South Carolina
Bless her
or
heart.
North Carolina or Miss Maine, for that matter. I'd like to close with one question. Any words of wisdom to the younger lawyers coming out of law school, passing the bar, going to work either as a sole practitioner or working for a small or big firm, in terms of your guidance based upon what you've seen in your years of practice?
If you're in private practice, hire an accountant to show you how to keep your books. That would be number one up there. And communicate with your clients. It's been, I think the AMA, the American Medical Association, right, did a study one time that showed that that doctors who get sued for malpractice, as a rule, do not screw up any more frequently or any worse than doctors that do not get sued. The difference between the ones that get sued and the ones that don't get sued is that the ones who get sued more have attitude problems, are arrogant, don't listen to their patients, and the ones that don't get sued have a kindly desk-side manner, and the client really cares for them and thinks that the lawyer cares for them. And so I would say communicate, get an accountant and communicate.
Do you think that, along the lines of what you just said, do you think if a lawyer believes that he or she has made a mistake, that the best first step would be to sit down with the client and discuss it?
Absolutely.
Have you seen in your practice that if a lawyer doesn't do that, that it tends to lead to disciplinary complaints?
Yes, I have, on several occasions.
Okay, anything else you'd like to add, or are you ready to get this over with?
I'm ready to go.
All right. Well, I thank you very, very much, and I really appreciate you taking the time and being willing to put yourself on the spot, and for being forthcoming. And
I'll probably look at this and shoot myself. No, I won't do that.
All right. Well, thank you, Jenny. We're going to go off the tape.
Okay.
All right.